this presentation, I've often done as one full workshop that can take it with lots of discussion with it between everybody, can often take up to a couple of hours. So I've broken this up into two. So today we'll talk about what intellectual property is and sort of what does it feel like effectively from a researcher's point of view to be part of that inventive process, and some of the things that you need to be very much aware of and doing as you do your research in order to prepare yourself, if you like, for ultimately patenting an invention. And then in about a month, so later in May, we'll come back to this, and then we'll talk about the whole patenting process and what that involves, and how it unfolds over the years after you finally submit a patent application. So, all right, so diving into this then, what is intellectual property? So simplest way of defining this is, in fact, to define it in terms of what it isn't. It's effectively not any kind of property that is of a tangible form, which are all the familiar kinds of property, houses, cars, bits of artwork, other things that you can get a hold of, so to speak. So those are tangible forms of property. And if you think broadly about that for a moment, you realize we've got massive legal systems very historically, so surrounding how to own those and record the ownership and transfer it and so on and so on. Intellectual property is everything that isn't of a tangible form. And equally, over time, we've developed sophisticated legal processes for handling the ownership and commercialization of intellectual property. So it's ideas, so things that come out of your head, basically, methods, ways of doing things, any form of creative work that ultimately is defined in terms of what that idea is, as opposed to the thing that it actually makes. That's a subtlety that comes up later when we actually patent something. It is ultimately about the invention in terms of the idea, if it's manufacturable. So to sort of crystallize that further, if we think about then the different kinds of IP that you'll all have come across in everyday life, there's a number of them. Patents are the one that most of us will be most immediately, as researchers, dealing with, both looking at them and ultimately producing them, hopefully. So we're going to spend most of our time talking about patents in this couple of webinars. But if we think for a moment about the other kinds of intellectual property that, of course, we come across every day in our everyday lives. So first of all, copyright's a very important area, and we bump into these all the time, so to speak. Can anybody shout out or type into the chat box there? So what kinds of copyrights can you think of that you literally come across every day, and sometimes unknowingly so? Where do you come across copyrights? And who do you think owns them? Any question? Any comments here? Type them into the chat box. Yeah, here we go. So publishers, correct, are usually the ones who ultimately own a copyright. And while others are thinking of more everyday forms of copyright, let's talk about this one. You know, as we publish a paper, and especially some of the graphical elements, graphs and figures and so on in a paper, we almost always have to sign over the copyright to the publisher in that. So we are the creators, but we very quickly hand over the copyright and therefore the right to earn some income from our creations to the publisher, who then variously makes money. And the big publishing houses in science make quite a lot of money from publications, all on the back of our effort, so to speak. So it's an interesting part of academic research. You're going on through these. Yes, Angus says, sorry, Yeah, somebody says, yeah, video content, absolutely. Your own thesis is usually copyrighted initially to you, but in some cases you might have to assign that copyright over to somebody else, depends who's funded the research, and so on. So quite right. Trademarks. Where do you come across trademarks? Give me some examples of trademarks that you might come across in everyday life. Lots of them. Logos. Just about every brand, and that's not, by the way, why this picture of Lefroy Scotch whiskey is sitting on the screen here, but that will be trademarked. The whole style of the lettering and all those sorts of things is all probably trademarked by them, almost certainly so. But so every time you see something like that clearly has a style that is maintained for a period of time, that will have been trademarked and protected. Each of these main types of intellectual property have a legal protection mechanism around them. And for example, if I wanted to, because I do like Lefroy Scotch whiskey, I wanted to make a T-shirt or something like that and print that particular style of lettering on that word across that T-shirt, I would have to get permission and probably pay something to the company in order for that to be legal. Right? And it's very well known, since there's so many. Disney is a good example of a company that makes a lot of money out of trademarks and copyrights. If you want to use anything from Disney, they have a company called Buena Vista, and in Victoria, their head office is in St Kilda Road, and you have to contact them, tell them what you want to do, print a T-shirt, something like that, print a poster, and they'll tell you what it's going to cost you to have that right, to have the right to use the mark. And they may not actually give it because they protect it quite strongly. Those of us at Monash were amused in the last year or two at just how tightly controlled the Monash branding is. If those of us within Monash don't use the right branding or use it in an inappropriate way, Monash can be quite sticky about that, for example. Yes, art is a form of copyright. Trade, everything to do with McDonald's would be as somebody says, they're a trademarked item. Amusing item in the news that over the last 24 hours, with New Zealand just releasing its lockdown, where everybody was absolutely required to stay home. Now they're more allowed to get out. The first thing that a huge number of people did very early hours was rush out and buy their first McDonald's hamburger in a month, with huge queues snaking around streets. Okay, moving on. A couple more subtle ones, but very important ones. Know-how is a form of intellectual property. Now, can you all think for a moment where or sort of what examples that you could be aware of know-how being an important, where do you come across something where know-how is an important form of intellectual property? And this overlaps a little bit with trade secrets. These are overlapping. Yes, the Coca-Cola recipe, Justin, quite right, is a very, very famous example of a well-kept trade secret. I don't know if it's ever patented, but it's very old, the Coca-Cola recipe. So it's kept very, very secret, and that's the only way that Coca-Cola can sort of maintain its novelty, if you like, around that product. Interesting. Cooking and things to do with recipes are, if you like to say that chefing and cooking are terrific examples of know-how. So there are certain things that certain skilled cooks and chefs can do that maybe aren't even easily put down in a recipe, but there's just little details and things that are done by an experienced chef that you would have to call know-how. So, in fact, all of you, hopefully, are the embodiment of a significant amount of know-how. In fact, you're all in this webinar because you've been educated for at least 4 or 5 years at the postgraduate level. So what have you been accumulating during that time? Know-how. It's valuable. You could value it just in terms of how much it's cost to give you that education, and it's a substantial sum, well in the hundreds of thousands of dollars, and you could value it in an alternate way in terms of what your earning capacity is in your future career because of the things that you know how to do and the knowledge that you have. That's know-how. So know-how is usually found in people, so to speak. What does Kyle say here? Skilled trades that need a license or certificate. Correct. All of the skilled trades are a good example of know-how, and that, in fact, is a good segue. Thank you, Kyle, into the what I called here the strange history of the way that we have constructed the legal frameworks around most of these kinds of IP, but in particular patents. So this history, very briefly, if you go back to the Middle Ages and you look at various successful civilizations during that time, let's just pick one. For example, the Venetians, who in the 12th and 13th centuries ruled a very large part of the Mediterranean seaboard. One of the things that they did was they quickly recognized how valuable glassmaking technology is. And was then too. Windows, tableware, all sorts of items that could be fashioned in glass. And wherever they went, they found anybody that knew anything about glass, forcibly removed them to the island of Murano, just off of the main island of Venice. If you've ever been to Venice, or if you ever get to Venice in the future, go out to Murano and you'll find one of the greatest concentrations of glassmaking know-how in the world ever. And most of it's still there, and you'll find people there who are able to do things in glassmaking. One of the things that's always mystified me is twisted stem with various colors and strands of bubbles and so on, that even today there are very few people in the world who know how to do these things. So the Venetians made vast fortunes by dominating, monopolizing, it's an important word, monopolizing the trade in glass, because they had the only people in most of Europe who knew how to make glass for hundreds of years. Others, as they became a bit more aware of the bigger world, started to get a little jealous of this, such as England. And the English realized that they were going to have to provide some encouragement in order to bring these sorts of skills and keep them established in England. And this, by appointment to the royal family, was effectively how they did it. They said, we'll give you a royal charter to supply, and we'll allow you to do so as a monopoly. So you're the only one in England that's making a certain kind of glass for a certain purpose. If you commit to doing this in England and establishing that skill base in England. So then fast forward 100 or 200 years as parliamentary and legal systems developed in England, that royal charter became the system of patents that we know. And what they said was, yes, you can have this monopoly in order to make whatever it is that you're making, if you do two things, or with two sort of conditions around it. First one was you had to write it down, because by writing it down, it made it permanent. It was in the record and anybody could come along in the future. Whereas, I mean, Murano is still there as a source of glassmaking expertise in the world today, but there are many forms, many civilizations that have come and gone over the last 2,000 or 3,000 years, and their know-how, their technological know-how in many cases has disappeared with them. Okay, so this was a way that the English said, right, this is going to get written down, whereas it previously wasn't, and thereby this knowledge could not get lost. It could also be passed on, and they said you can have a monopoly, having written down and effectively published your methods. You can have that monopoly for 21 years, and after that, it's free for anybody to use. So this is a clever system of encouraging. 21 years then was about the period of a working life for a tradesperson, a master craftsperson of some sort, mostly men at that era, but these were the master glassmakers and metal workers and stonemasons and so on. And after 21 years, then the monopoly dissolved, and your knowledge, if you like, was then free for everybody to use. In particular, your apprentices. So during that time, you would typically be training apprentices, and an apprenticeship in those days was 7 years. So this was the period of 3 apprentices. And by the time that those 21 years was up, then those apprentices were fired and ready, so to speak, to be to take up this knowledge freely, and then the technology became widespread throughout the country, and this worked. So the UK, or the English legal system, then became the basis for the patent legal system throughout the world that followed, and we still more or less have those features of the patent system today. Okay, so there's a little tiny bit of history. Moving on then to one of the key points about this is that this key point is that it had to be written down. That's the whole purpose of it, because the knowledge that you have, you're entitled to a monopoly to earn something from it, but for a limited period of time, and then it has to become public. That's that 21 years. And right back at the beginning, for all of us as researchers, one of the key points is it's got to be written down. It all comes down to lab records. Why do I feel that I've missed a slide here? Yes, I thought I'd missed something. Sorry, I skipped, somehow I skipped that. We'll come back to that. If we're in the business of doing research, and IP of a valuable sort might be originating from it, one of the first questions that comes up is, well, who has contributed to it? And immediately then we get confused as researchers, as academic researchers, because there's another form of publishing this information that usually comes after patenting, if we've decided to patent it, which is authorship. And to sort of summarize the outcome of that kind of divergence, simply, authorship can be more broad. Broadly, it would recognize all who contribute in some significant way, intellectually, but sometimes more practically as well. On the other hand, an inventor, the inventorships, again, it's usually a number of people, but it's very important that that is more narrowly defined as to those who have made a significant, these are the key words, significant intellectual contribution to the actual idea. Right? So it can go back to that. So the point here is that there might be people who are recognized for a contribution. Perhaps they ran an electron microscope, some SEM images that were rather important in verifying that something was as designed, so to speak. They would always be recognized probably in a paper, but they might not be considered inventors of the original idea, if you see what I mean. So often there are analytical and other contributions to a paper that might not be recognized in an inventorship. Getting the inventorship and the authorship in both cases, it's an important task. And let me tell a quick story, if I don't run out of time here, about this. I'll make this quite quick. This is the story known to some of you in more detail about how this can kind of go wrong. And this is more of an authorship dispute, but if it had been an inventorship dispute, it would have been very serious in a legal sense. So this story goes back to Monash quite a long time ago, and I won't obviously say who these people are. We'll just refer to them as Professor X or Dr. Y. But at one stage, Professor X was doing a piece of research which ultimately became quite exciting, and a paper for Nature was being written and just about to be sent out. But in the preparation of that paper, the postdoc, who was the person doing most of the work, had run into some problems. And sort of in front of the mailboxes one day, he had been chatting and frustratedly venting his frustration, and had chatted to one of the other academics, Dr. Y, about this. And Dr. Y had said, "Oh, I think we've done some stuff like that in the past. I reckon maybe we know how to kind of solve those." So the postdoc sort of said, "All right, look, thanks. Can I come and see a bit about that sometime?" And did. So some time later, I went and sat in the office with Dr. Y and sort of went through exactly how to do this thing and how to sort of overcome these problems. But when the paper was about to leave the department, Dr. Y sort of spotted an early draft of it and suddenly realized that his contribution to this hadn't been recognized, and began to raise quite serious questions about it, which which, you know, the threats of legal injunctions and whatnot got quite serious at one stage. So I was asked to sort of mediate and trying to find out what had happened, and the story, as I've just told it, was what had happened. So eventually, when I was talking to Professor X, he said, "Oh, look, you know, we know how to do those things, yada yada yada." But that's not how the postdoc had understood it. And I said to Professor X, "Okay, well, look, if you've ever published these techniques, or no, we didn't need to publish anything quite like this. Oh, well, all right. If anybody in your group has written it down in a thesis or in their lab books, or even in your own notebooks, Professor X, you know, that would just establish, without any question for Dr. Y, that you guys knew how to do some of this stuff." And it turned out that Professor X actually had no one in the group had ever actually done it in a way that had been written down and described as procedure, nor had he written down, "This is how you might be able to do it." And I had to say to him, "Look, I'm sorry, but if something like this isn't written down, it basically didn't happen, right?" And so I eventually had to persuade him that because there was absolutely no record of this sort of thing having been done in his group before, that there was no basis for him to claim. So he just stopped claiming that that they knew exactly how to do these things, because clearly the postdoc didn't know how to do it. And so eventually then Dr. Y was included on the author list. So that's a little salutary story about how authorship disputes can arise. And when I talked to the postdoc, I said, "Why did this happen? Why did it not ever occur to you to mention that you'd had a good, deep conversation with Dr. Y about all of this?" And he said, "Oh, look, I thought he probably could have been an author here, but I was a bit scared to say so." So that's a warning to everybody of the younger generation here. Actually, you have a strong responsibility to talk to everybody who's on the authorship or an inventorship. It's not one person's decision to make. It's the whole group who are authors. They're all responsible collectively for making sure that everything has been recognized properly. Nobody who's been left out that might be in, just put the proposition forward to everybody. And equally, nobody should be in that really hasn't made any contribution. It shouldn't be automatic that somebody's name is included. Okay, so you should always ask and keep it discussed. So these things come up. In authorships, they are sort of a matter of some stress, shall we say. I've come across 2 or 3 in my career, not as being involved, but as in my role as academic research integrity advisor in science at Monash. I've come across maybe 1 of these in the last 10 years that I've had to try to resolve. So they do come up, and if they aren't sorted out sort of quickly, they can become quite serious. Same issue applies for inventorships, but it's a much more insignificant legal matter. And occasionally the patent attorney will recommend, or your university IP department will recommend, that an independent person is brought in to kind of do an audit, to talk to everybody and make sure that the right inventors are recognized. So it's a serious matter, and it's something that everybody should take sort of seriously. Okay, so then coming back to that point then about if it ain't written down, it didn't happen. How do you make sure that your work is properly recorded in preparation, if you like, for your IP to be recognized? Well, the first thing is it does have to be noted, and the form of your lab notebooks and your records is very important here in this regard. It's important in other regards, including research ethics. But in terms of IP, one of the things you might want to keep in mind is that if you do come up with a highly important invention at some point or other that is patented, and of course people spend vast sums of money in court cases on patents, you might find that your lab books are in court one day and you're in the dock, so to speak. I'll come back to that next time. But being cross-examined by some very clever intellectual property solicitor or litigator quizzing you on what's in your lab records. Just keep that in mind, right? And if I emphasize that quite strongly, it's because one of my earliest patents went on to become something of some value. And I'll have to say it's worried me for many years that that my lab records were maybe not quite as tidy as they should be. You know, sort of pizza delivery guy's phone number in the corner and bits ripped out because I had a phone message written down for somebody else on it. You know, stuff like that, everyday stuff. But it would be very embarrassing if I had to sit and defend those in court. So it's just a reminder about this. So how do we do this? All right. Normally, if I was doing this live, I would pass one of these books around. But if you can all see this, I've taken a picture of the sort of lab notebook that is recommended by one of our patent attorneys and that works with Monash. And what do you see here? You see, first of all, numbered pages, right? And there mustn't be any pages removed or anything apparently stuck in. There mustn't be anything that looks dodgy once this goes into the record, so to speak. We've got, if you look at the other things, you can see how work continued from other pages. It doesn't matter if you're doing a number of experiments. You can even have multiple books for different things that you're doing. That's all fine. But somehow or other, the book needs to be organized in a way that people can follow it. Definitely no text apparently rubbed out or redacted, you know, sort of scrubbed out with it, you know, scribbled out some way or other. You can put a line through something if you basically wanted to rewrite something, but it mustn't ever be obviously removed in such a way that people can't see it. That looks extremely dodgy if you do that. Ideally, what that says down there is signatures. Ideally, not ideally, formally, lab notebooks should be signed off. In some places like CSIRO, I'm fairly certain it's done every day. Certainly in some biotech companies it would be. Perhaps if things are not quite that intense, then every week would be appropriate. And you might notice down the bottom of the page there's a witness to that. So that could be the signature would be you, but it would be witnessed perhaps by your signature, by your supervisor, and then dated. Okay, and it's certainly not valid to go back and do this sort of 6 months later. If that's discovered, if you like, later, then that would invalidate it, would just be thrown out. Interesting, yeah, somebody's asking, I think, from Pete, yes. What happens in the digital world? We had down here, we had Beck talking about using digital lab notebooks the other day, and oops, and what has happened with electronic lab notebooks and the electronic records? So here's a quote from the US Patent Office that records such as this can be satisfactory, shall we say, can be admitted as evidence, but they must provide evidence that the records being submitted have not been altered from the original records and that signatures are authentic and that dates are accurate. Now, what that means is that a lab notebook, electronic lab notebook is okay in principle, as long as the surrounding infrastructure, electronic IT infrastructure is robust. So each of us works in an organization where timestamps that are on central drives and repositories of information, etc., are all adequate, I hope. I'm not completely sure of that, but I think that's true. One thing I think we need to be wary of is that in the longer run, the definition of what's adequate in the IT sense might change. But the key thing here is that an electronic notebook that's maintained on your computer probably isn't enough. It's going to have to be archived at some point of time as some version, sort of frozen at that point in time on the university archive, so that the dates are all frozen and that it's clear then that in the future it's never been tampered with. Right? That's the kind of issue that we need to take care of. So it's a record keeping and archiving issue, but fundamentally it's okay to use an electronic lab notebook. But each institution, if we're concerned about this, should probably raise this with your IT support people and just refer this sort of phrase to them and say, you know, once we archive these, you know, are they being then sort of properly time-stamped and frozen? That's an ongoing topic of discussion. So just moving on from that. So that's taken us through, if you like, sort of what we need to do on a day-to-day basis in the lab. Remember, those lab notebooks are important. We need to keep track of kind of what we're doing in this regard and who we're working with. That's the whole authorship and inventorship case. It's not to say that you shouldn't work with people, not at all. Collaboration is the key to success in these things, but it's important to have a clear idea as to who's doing what and why. So you think you've got an invention, then the next step is patenting it. Right, so an invention itself is just the new idea and the demonstration of it. The patenting is how you protect it, and the process of what we do next, so to speak, is what we'll talk about in part 2 of this this discussion. So that was where I was going to leave it today. So let me go to some of the chat questions here and shout up in chat if you want to ask any questions. Somebody says, is it common for PhD supervisors to sign off on students' lab notebooks on a regular basis? And the answer is very clearly, it should be. Now, I've quite answered your question, or you can see what I'm saying. In other words, it's not maybe as often done as it probably should be. Certainly from an IP point of view. And so you all students and young researchers might say to yourselves, well, I think I'm doing something. I'd hope you say this to yourself. I'm saying, I think I might be doing something that is patentable in the long run, might be valuable. I'd like my records to be as fully formal as possible. I need to get my supervisor to sign off, or at the very least, somebody to sign off on it. A postdoc in the lab would be sufficient. It doesn't have to be the supervisor, but it's good if it is the supervisor. So it should be done, but I'll have to admit to being as less than completely perfect on that as probably everybody else has, but it should be done. Any other questions? Comments? Do all have a look at your lab notebooks and just make sure that you've got some of those main elements present. The numbered pages, very important. Somebody says, Tony says, I thought it had to be an independent witness, one who's not involved directly in the research activity. They should be able to understand what you have done. I'm not completely sure about that, Tony. I suppose that is certainly stronger. Certainly, it would be stronger if it was not somebody who was otherwise involved in what might be the invention, if you see the conflict of interest that otherwise arises. So the subtlety there is that if it's somebody, it can be somebody in the lab, but it's not somebody who you're actually working with on this supposed invention, then they've got no conflicted reason for wanting to sort of help you be fraudulent or anything like that. So it becomes a stronger signature if that witness is not a co-inventor. So at the very least, try to avoid a co-inventor, which the supervisor is, of course, usually a co-inventor. At the end of the PhD, should the student or the university archive the lab book? The university must always have a copy of your research records, whatever form they take, lab books or electronic. The university needs to have those both from an IP point of view, but also from a research integrity point of view. So we are required by the ARC and the NH and MRC and all other public funding bodies to adhere to certain codes of research integrity, and that includes record keeping, especially for publicly funded research. So there's a strong reason why you need to take care of that, and most labs will have processes for making sure that records are in the right place and so on. But if you're not so clear on that in your own group, you might want to bring that up with your own group about how this actually works out in the end. It's best if you're aware during your PhD what it is that you're going to have to kind of leave behind you in a tidy way, so that it conforms to the various requirements. Yeah. Tony says, same research group under an NDA, but witness not co-inventor. Yeah, that would all be fine. The NDA, maybe we'll hold that comment, Tony, thanks, about the NDA till next time. I'm going to talk about confidentiality in part 2 here, but we'll come back to how closely within a lab group that needs to apply. Dimitri says, how to share inventorship between student and supervisor? That's an important question. And of course, there's often more than just the two of you. There can be multiple students or multiple people and supervisors, right? So this can be anything from 2 to 4 or 5 people. And what you have to do is, and certainly this is what I've done in the past, is I've tended to put forward a proposition, shall we say, to everybody that seems fair, and it's not necessarily, equal shares is a great way to start, but then you might say, well, so-and-so clearly did a lot more, contributed a lot more to this than somebody else did. So I've often put forward a proposition to everybody that's involved, but doing it publicly, so to speak, to including our main group IP advisor, who is not ever an inventor but knows sort of most of the people fairly well, and then said to everybody, right, I'm just one of the people involved in this. If you have any comments and if you want to sort of have this looked at further, talk to Angeline, right? So providing everybody with a mechanism other than me, because I'm conflicted, obviously, other than me, to sort of get some further advice, thrash it out. And if there's a dispute, if there's no agreement easily reached, then what the universities will typically do is bring in an independent person, that could even be a patent attorney, who will talk to everybody, try to sort of understand where the issues are, and then propose a solution meaning a share. Okay, so there are multiple levels of sorting that out, and all I have to say is, at least in my patenting experience, I've never actually ended up with a numerical dispute about that sort of thing. Hang on, where do we get to? Pete says, yeah. So there's 2 points there, Pete. So his point about linking things is one that I'll have to say that we're still grappling with a bit. I believe, I don't know whether Beck is online, but when we were talking about this in one of our group webinars a week or 2 ago, Beck was talking about electronic lab notebooks. And I think what she was saying was that there was a way of linking to external documents out of her lab notebook, electronic documents, which might be a data file of some sort. And that, as long as that's probably in a particular folder or location on the main archival drive, so you can imagine how you could set up a folder that has the notebook and some of the supplementary documents, which could be a very large number of supplementary documents, and all of that gets archived all at once, linked by a hyperlink to the lab notebook. Then everything's tidy, and frankly, a lot tidier than it could ever be with a paper notebook. But that's something to really sit down in each place and think how best to solve that problem. And if I'll say to everybody, if you're mainly relying on, perhaps this is the biggest sort of point to come out of this bit of discussion, if you are relying on paper lab notebooks, but of course you're generating a lot of data files and possibly ultimately printing those out in certain ways as primary data, you need to think carefully about the data trail and how to link, the detail of an experiment with the final graph or whatever it is, or spectrum or whatever that you produce, and the data file behind it, because even some journals are requiring that data file be uploaded, right? So you need to always know in your lab notebook, maybe you might even have to write this down. You have to write down a file name and its location, its path, in order that you can immediately go from lab notebook to data file, or vice versa. And I just put that out there as a challenge to everybody. Make sure that you actually are able to do that. It's easy to not have good habits in that regard, and suddenly you've got a bit of a mess. Oh, where is the detail for that particular spectrum that I've got here in my hand. Right? Electronic notebooks actually make that a hell of a lot easier. Okay. Pete also says, all institutions have different IP sharing policies. Indeed, inventors should make themselves aware of this. Absolutely. So when each of you signs on, either as a PhD student or as a postdoc or an employee, effectively, you should make yourself aware. I think you usually are signing that you are aware of the university's IP policies, and how that all sort of works out. So the information is there, and you shouldn't be very hard to find, and there's every reason you'd want to know what it is. As an example, at Monash, the sort of the top level sharing policy is that the inventors are given 30% of any monetary return that comes to the university, and the remaining is effectively split between the university central and the faculty / school that supported the research. Obviously, both paid serious quantities of bills supporting the research, so that's not a bad deal. So the inventors get 30%, and then what I was talking about before in answer to Dimitri's question was how that 30% gets split up between the inventors. And at least at Monash, there is no edict, if you like, in the headline policy about how that is done, other than that satisfactory and agreed arrangement must be reached early in the process. Pete's saying lab archives, yeah. Correct. All of that costs dollars, and I think Beck was saying that at Monash, so just certainly in terms of the electronic lab notebook, that there is one that is part of our sort of provided suite of software, so that's available at least to zero cost to us locally. And of course, the centralized file storage and archiving system is all, we all have that. And I think from a point of view of university level ticking various requirements, including research integrity, always archiving in the university as opposed to your own. You should have your own archives, make sure they're secure, but for what you might call formal archiving, you should use the university one, because that way the university is responsible for it, not you. So there's clearly some more to be talked about there. It's almost another webinar, Pete, and others, about some of this record keeping, record linking, and record archiving question that we're all trying to grapple with at the moment. All right, good. Any final comments or questions? All right, we'll leave it there for now. So as I say, in about a month's time, we'll come back. You'll all be ready to hopefully you're all going away and thinking, well, which is my patentable invention here? And then I'll take you through how that actually all works out from the moment that you first think, ooh, I've got an invention here, what you might call the eureka moment. So let's have your eureka moments, and then we'll see what you're going to do about it, and will it ultimately make any money, and how does that work out? Okay, so enough said, and we'll see you all in about a month. Cheers, everybody.